Or yesterday I mentioned
What is the position today?
battery is not listed today.
Not listed.
Give some preference because my lord, the urgency is there.
Achha. What was it? What was the issue?
Issue my lord, regarding Group D recruitment. 600 poster lying vacant.
It will be there. Monday it will be there.
I would like to mention a matter for inclusion in your lordship.
If the inclusion slip you may give. For inclusion. Give the inclusion. Number one.
Number one, my lord, I am for the petitioner, my lord.
Lordship, I appear on behalf of the state. Lordship, I pray for some time. Yesterday, I have received the brief. I have not gone through the brief, Lordship.
Let's see. Yes. Pending matter.
Yes, my lord. Pending filed before, my lord, when the administrative member was there, my lord.
Let's see what is your problem.
My lord, may I tell your lordship, my lord, before you. My lord, in 2007, my lord, the agricultural department issued a notification for appointment of persons for lower division clerk. My lord, in 2000, thereafter, my lord, government fit that I would cancel the selection process. They cancelled the selection process. My lord, that was challenged before the tribunal. Tribunal set aside the cancellation and directed the, my lord, the authorities to proceed with the selection process. My lord, that state challenged it before the High Court, my lord. Division bench upheld the order of the tribunal and directed to fill up the vacancies. Against that, a review was filed by the state. Review dismissed. Against that, SLP filed. Ultimately, SLP withdrawn. Thereafter, my lord, candidates preferred a contempt application. In the contempt application, the division bench directed you fill up the 331 vacant post within a period. My lord, thereafter, they filed a report saying that we could only fill up 234 seats because the other seats belong to exempted category. My lord, thereafter, again, a matter was filed before the tribunal relying upon a, my lord, order of 2005, wherein it has been stated by the government that if exempted category seats are unfilled, those vacancies are to be converted in corresponding, my lord, unreserved SC, OBC. Following that, my lord, the tribunal passed an order, you convert. My lord, thereafter, what the authorities did, authorities published a notification that appointments will be given in terms of 2013 rules. Again, that was challenged before the tribunal. Tribunal set it aside. Thereafter, again, my lord, state preferred a appeal before the division bench upheld, state went before the Supreme Court, SLP dismissed. Ultimately, my lord, in 2014, certain candidates were given appointment and raised, that is including the petition, was given appointment in 2017. Now, my lord, we were eligible to be appointed in 2014. Now, my lord, I was appointed in 2017. My lord, I retired from service on 31st of December 2025. My lord, now my contention is I am shortfall of service, my lord, for 10 years qualifying service. Now, my case, I gave a representation before my retirement. It was not considered I retired. My lord, I filed the tribunal. My contention is, my lord, the fault and latches on the part of the respondents, I cannot be made to suffer. This is the point. My lord, since there are lots of events, my lord, for your lordship, I only prepared a list of dates so that I am also giving.
So you were party to which proceedings? Earlier proceedings?
My lord, I was never, my lord, I never filed any writ petition. Every time the order was in rem, my lord, it has to be applied. My lord, I am also giving a copy of the list of dates to my. This is the issue involved, my lord.
So you are relying upon some judgment.
My lord,
only issue is someone who is appointed in 17, whether he can get benefit of any period prior thereto, though admittedly in your case you are not pursuing the matter.
My lord.
You are not pursuing the matter. You are not a party to any of the proceedings.
My lord, I was not a party. The order was not, my lord, in personam. It was all.
That's That's not an issue here.
Yes.
It's not that you have been appointed. If it
Yes,
was
ma'am.
not in rem, you would not have been appointed.
Yes, in red.
So normally therefore we are saying which judgment supports your contention that even though you have not pursued, but you should be given the benefit of any back service.
No, my lord, I am not wanting the benefit to be precise, my lord. The appointments pursuant to the direction of the honorable court, appointments were given to certain batch of candidates, 234 candidates out of those 331 vacancies. Because of a
Now you are repeating that all you have said.
yes.
For 234 out of 331 appointed, rest not appointed because exempted category was not available. Again, other persons pursued the matter. Finally, it was directed that you convert it as regular or general or go by the normal roster.
Yes, yes.
In that process, finally you got selected in 17, but prior to 17, you are not one of those persons who has pursued the litigation.
No, I am not one of those.
Therefore, can you claim any benefit? That's why we are asking you what is the
My
law,
lord,
let us see.
with the best of respect, my lord, the petitioners can, my lord, because, my lord, when in a selection process, when appointments are being awarded given in a selection process, my lord, there my right accrues. When I am in a similar position as those of the other candidates who were given appointment in 2014, when I equally sits equal with them, my lord, my right accrued in 2014.
After 234 appointments were made, there must have been a separate procedure.
My lord,
There
no, my
must have
lord.
been a separate process.
No separate process, nothing. They said that we could only, the direction was to give appointments to 331. Just Honorable Justice Nishita Matre, as his lordship then was, presided specifically, my lord, in the contempt order, gave a direction due to give appointment to 331 vacancies. And laid down the guidelines how the appointment should be made.
There is the order passed in OA 92 of 2015.
My lord, if your lordship first comes to page 103 of the 103.
So where is this order of 7/6/2016?
Yes, ma'am.
Where is that order? In OA 453.
Hundred and 12, my lord. Operative part is 109.
119.
119 is the operative part.
And OA 92 of 2015.
My lord, we 92 order, my lord, we could not find in the humanities. We have it is not available in the server, my lord, we could not obtain.
29/2/2016 order.
29 February 2016.
You are a beneficiary of that order.
My lord, division bench order I have against which they have preferred.
Against, sorry?
My lord, that February,
Hmm.
29 February 2016 order, appeal was preferred before the division bench. That division bench order, my lord, I have
4816.
4816.
Where is that order?
121, my lord. And operative part is 124. Against this order, my lord, a special leave petition was filed that has been dismissed.
Can you claim a parity with these people?
Presentation is at 147.
No, that is your representation. What we are saying is how you can claim a parity with these people.
Yes, my lord. How I can claim parity, my lord? The 2005 circular, which was already in operation, my lord, before this election process was advertised. This 2005 circular clearly, my lord, mentions that in case suitable,
Have you been given any benefit of this order?
my lord, which order, my lord? Yes, pursuant to that order, because I was only I was given appointment after conversion of seats from exempted category to corresponding.
Correct. So therefore, you cannot claim parity with these people. They
No.
were part of the original panel.
No, my lord, the panel, my lord, may I make myself, my lord, my lord, the panel is one panel. My lord, the authorities ought to have initially in 2014 converted those vacancies following
Sir,
the.
we are not on that. We are asking you, you want a benefit of the past period because you say it was protracted by them. That is the sum and substance of your case.
Yes.
Admittedly, you never pursued the matter. You are a beneficiary of this litigation. So it's not a question of you being pursuing the matter and that it has been delayed by their side and therefore you are already in court, therefore you are in a position to claim anything for the period which was unduly protracted by them. Those who the court found to to be entitled to such benefit was granted in OA 92 and by this division bench. It was said that their appointment will relate back because they were originally pursuing the matter. Admittedly, the benefit of this order was not given to you.
My
You
lord,
came in much later.
my lord, I admittedly, your lordship is absolutely right. I did not.
So therefore, these being the facts which neither you can change nor it cannot evolve.
Yes.
What is the law? Let us see. That's what we are telling you. Someone who has never pursued the matter, but is a beneficiary of that proceeding, can he claim a benefit for a period prior to his being born in the service? Let us see.
My lord, in that event, my lord, today I have not brought any judgments, my lord. I can, my lord,
Because these facts are not in dispute. It's only an issue of law. If you can sustain your claim with any law, then
yes, my lord, it's only based on
yes.
point of law.
Huh? You. It's very well organized list of dates.
My lord, I have served to the
Yes.
8th September.
It's to the point and it is in chronology, not missing anything. It's
sir, unnecessary. Your lordship only point.
no, thank
My
you
lord,
very much.
probably, my lord, my learned friend will not dispute the facts. Then
Therefore, I have said, if they want to dispute next day, they want to file an opposition, we will not stop them. As of now, we don't think that there is much dispute. You have fairly said that you are not a party to the earlier proceedings. So therefore,
Grateful, my lord.
number two.
I'm appearing for the applicant, my lord. Application number 2 is my application. And number 2.
We are on the review applicant. The husband is
Today I am filing the affidavit, my lord.
Opposition.
No, my lord, complying the last order. Your lordship, last occasion directed us to file the supplementary affidavit annexing the RTI reply.
The review order passed by which bench?
This range, my lord.
by justice.
Oh, so we can consider.
Order passed on 7th October 2024. The appeal.
May I comment by the event opposition, your lordship? The CAT 2, my lord, was filed thereafter supplementary. Now, my lord, against them, both the CAT 2 and supplementary, we have opposition. This is my opposition. And I have, my lord, should be getting, my lord, I have filed it belatedly and I have served it yesterday only. My lordship, my learned senior friend want to file it.
You want to reply?
No, my lord. It is admitted fact that he served a copy of the reply where he admitted that the annexure which I have annexed in this my reply, annexing that the present salary is 1,04,799 he admitted. Kindly come to the paragraph, page 31 of his.
Issue is of maintenance.
Yes, yes, my lord. In the appeal court, there was an order.
Which page? Hmm. Page 2. You were appearing in the original appeal.
No, my lord.
You were appearing in the appeal. You are the advocate appearing in the appeal. Then how you have filed the review?
Yes, my lord. I'm grateful, my lord.
Yes, tell us. Can you do it?
It was filed by the Australian.
Yes.
Writing change after it has been filed, my lord, I have
Who filed it?
Again, Shaunak Bhattacharya was appearing in the appeal, my lord.
they have HON'BLE advocates who have filed.
Who is it? Tell us, show us from the record. Who has filed and who was there on record in the appeal?
Your Lordship, can you take the review application for it? My lord, you find
No, please see. This thing I have noticed after coming here that so many reviews are being filed by lawyers who did not appear in the original proceeding. I want to be clear that it was the same set of lawyers. Just show, yes. Of the memo.
My lord, in appeal, affidavit of assets filed by Mr. Shaunak Bhattacharya.
Yes.
This is the affidavit of assets. Shaunak Mondal was not in the appeal, my lord.
No, he was in the appeal. Is a second lawyer appearing for the respondent.
Stonak Bhattacharya filed the affidavit.
No, that's not the point. The law says either he must have filed a vakalatnama or he must have appeared. Then only he can seek a review. So if he has filed a vakalatnama or if he has appeared, then there is no problem.
Power के file.
The vakalatnama we have sought no objection from Mr. Mondal itself.
From Mr. Sonak Mandal.
Yes. He was the vakalatnama.
But before the appeal court, when the order passed by the division bench, they filed the affidavit of assets, then the affidavit also filed by the Mr. Shonak Bhattacharya. I have the
Yes.
copy.
That hardly matters. That hardly matters. They were both of them are appearing in the appeal. Therefore, that doesn't matter.
My lord, kindly come to the page 20 of my application. Can 2.
No, the point is if we go into the review, then only these things can be considered.
Page 20 of my application is the interim order passed by the Honorable Division Bench.
12, 3 and 7. All right, we'll take it up in the next week.
Next week, my lord, with the application and
Everything. Yes, everything.
customers.
Then, as prayed by the review, yes.
Number 3.
Chief, I am appearing on behalf of the state and led by Ms. Learned AGP. On the last occasion, as per your lordship direction, I filed the report.
What happened?
Lordship, I am appearing on behalf of the state and led by Learned AGP. As per your lordship direction, on 14th August, I filed the report, and your lordship was directed if they file exception to this report.
Item 4.
My lord, I am for the income tax department, my lord. My lord, on last occasion, my lord has asked for a report from income tax department on last order. My lord, we yet to receive the report, my lord. Kindly grant us 2 weeks time for filing the report, my lord.
Ask you anything like
Were you appearing on the last day?
On that instruction has not come up. But, pardon me, my lord, but the instruction has not been come whether the suit has been filed or not.
Yes.
Anything that for grant me 2 weeks time or for
As played by learned advocate for the
pardon me, my lord, for my mistake, my lord. I have not seen the last order as per.
you should have.
I should have, my lord. I corrected myself on the
Yes.
future occasion, my lord.
Item 5.
My lord, I beg to appear on behalf of the writ petitioner respondents. My lord, I am led by Mr. HON'BLE.
And senior advocate T.N. Rai sir is appearing. But yesterday he rang me and told me that he will do the matter. Now I could not contact him. Probably he is appearing in some other court.
Paper books filed already.
My lord.
So if he is not there, how? We'll adjourn it for the day. Let him be here.
My lord.
Not today.
But this pertains to a matter regarding grant of gratuity of my lord, the previous director of Indian Statistical Institute, who is more than 70 years old. So, my lord, some preference. If you
Therefore, only not today we are saying. We're not.
But if it is fixed on some day with the time.
What do you mean fixed? It is not today means it will come tomorrow. Monday.
Obliged.
Item 6.
Item number 6, my lord, I appear for the petitioner. My lord, due to some personal difficulties, my lord, can it be not today, my lord? I have already taken consent of Mr. Banerjee, the private respondents. Only not today, my lord, nothing. Monday, let that be, any day.
Yes, not today.
Deeply respect.
In this matter, I am appealing on the zone of 4 and 5, my lord. My lord, can it be the pleasure of the lordship to take up this matter on Monday, my lord?
That's why not today will means it will take up on Monday.
Item 7.
7, my lord, I appear for the.
I am for the respondent number 1. I am for KMDA.
My lord, here, I'm sorry, my lord, I've got a throat today. Here, my lord, primarily the question is, my lord, land is the state government is the owner of the land. State government grants a lease to Milord KMDA. KMDA in turn gives the license, Milord, to the writ petitioner, that is Medinet Services Private Limited. Now, Milord, the question for consideration is, Milord, under which provision of the KMC Act the assessment of the building would be done? That had incidentally fallen for question before the court. But primarily, Milord, the writ petition was relating to, Milord, a rejection of, Milord, a prayer for mutation. Milord, they had applied for mutation before the Kolkata Municipal Corporation. Kolkata Municipal Corporation said that you please pay off the due tax, outstanding tax. That was the subject matter of the writ petition. Now, in that writ petition, Milord, a supplementary affidavit was filed by which, Milord, they challenged the process of assessment. Milord, according to them, Milord, the assessment would be under a particular provision. Milord, according to the KMC, it has been done under a separate provision. Now, Milord, this is the subject matter of challenge, Milord, before my lords, Milord. The Honorable Writ Court, Milord, has found favor, Milord, with the case made out by the writ petitioner, that under the provisions of a particular, Milord, section of the Act, where it has to be done. Now, this is, Milord, what is before my lords.
Yes.
Now, Milord, if your lordships may kindly have a look to Milord, page number 6. Now, this is the judgment under appeal.
6.
Thirteen 6/23.
Yes, ma'am. The writ petitioner, may I place a few portions of this? The writ petition has been instituted inter alia challenging a communication dated 13th of September 2013, whereby it was intimated to the petitioner on reference to the application made by the petitioner for mutation without no outstanding certificate, and it was also decided that the petitioners were liable to pay tax from 19/5/2010 based on assessment made by the Kolkata Municipal Corporation. In addition thereto, in the writ petition, prayer has been made to dispose of the application for mutation made by the petitioners on the basis of the registered lease deed dated 29th April 2013. The learned advocate representing the petitioners has drawn the attention of this court to the notice dated 5th of May 2011, whereby the petitioners were intimated that the annual valuation of the land in question was assessed at rupees so and so with effect from the second quarter 2010-11. Admittedly, such assessment of annual valuation of the land in question has been made pursuant to section 174(2) of the KMC Act. Now, this is according to the KMC, this is to be done under 174(2). Petitioners contend that the annual valuation of the land in question needs to be assessed in terms of section 176 read with section 171(8)(a)(ii). But this is where, Milord, the question arises. Though, Milord, I would be finally submitting that this issue cannot be decided in this petition. But be that as it may, Milord, this has been done. In support of such contention, reliance has been placed on the judgment of the Honorable Division Bench reported in 2016 3 CHN 590. While considering the points urged on behalf of the petitioners claiming assessment of land in question for the purpose of fixation of annual valuation in terms of law laid down by the Honorable Division Bench in Fabworth Supra, it has been brought to the notice of this court that the judgment of the Honorable Division Bench has been questioned by the KMC by filing a special leave petition before the Honorable Supreme Court, and it has also been submitted that leave has been granted by the Honorable Supreme Court and the appeal is pending consideration. However, in the same breath, it has also been apprised that no order has been passed in the appeal pending before the Honorable Supreme Court modifying, reversing, affirming the order under appeal. In view of such scenario, it has been submitted that there is no impediment So far, this court is concerned to rely upon the law laid down in favor while giving direction upon the concerned authority of KMC to assess the land in question for fixation of annual valuation and the property tax. Since question has cropped up whether during pendency of the appeal before the Honorable Supreme Court at the instance of KMC, during post-admission stage, whether it would be proper, so far this court is concerned to rely upon favor while deciding the issue involved in this writ petition. In answer to the aforesaid query, the learned advocate representing the petitioners relied upon Kunhamet delivered by 3-judge bench of the Honorable Supreme Court, placing reliance on para 44. It has been submitted that the doctrine of merger applies only in the event after invocation of the appellate jurisdiction by the Honorable Supreme Court order is passed in appeal, reversing, modifying, or merely affirming the order under appeal. It has been submitted on behalf of the parties that in the present case, there is no such order passed by the Honorable Supreme Court in the pending appeal filed by KMC. At best, it has been submitted on behalf of the petitioners that the order passed by the Honorable Division Bench in favor is in jeopardy in view of pendency of the appeal before the Honorable Supreme Court. Another limb of submission made by the petitioners is the effect of the order, which is under appeal in absence of order of stay granted by the appellate court. In this regard, reliance has been placed on the judgment of the Honorable Division Bench passed in Niranjan Chatterjee versus State of West Bengal. Based on the law laid down, it has been argued that any interim order passed in the appeal by the appellate court is binding upon the parties to the proceeding, but the law is equally settled that by mere passing an interim order staying the order operation of a judgment with certain further conditions, the existence of the judgment under appeal is not wiped out, and at the same time, for such interim order inter partes, the authority of a decision as a precedent is never undermined. The sum and substance of the argument advanced on behalf of the petitioners is that pendency of appeal before the Honorable Supreme Court, even after grant of leave to appeal, in absence of any order of affirmation, modification, or reversal by the Honorable Supreme Court, does not attract doctrine of merger, and this court is free to rely upon the law laid down by so and so, subject to the decision being taken by the Supreme Court in the pending appeal referred by KMC. The land in question, in respect of which assessment has been made by the corporation for fixing annual valuation and property tax, which has been questioned by the petitioners in the present writ petition, was first allotted in favor of the petitioners by the KMDA by executing an unregistered indenture on 23rd of July 2010. Subsequently, the land was transferred in favor of KMDA by executing an indenture dated 29th May 2012, which is at page 56 onwards. KMD in its turn leased out the said land in favor of the petitioners by executing a registered lease deed on 29th April 2013. After the land in question was demised in favor of the petitioners on execution of the aforesaid lease deed, the concerned authority of the KMC intimated the petitioners that mutation could not be possible since there was non-submission of no outstanding certificate, and it was also intimated that the petitioners were required to pay all outstanding taxes and they can apply for mutation with proper documents. The learned advocate representing the KMC while defending the stand taken by the KMC has urged that in view of the withdrawal of the writ petition being WPA 961 of 2012, on 9th of April 2013, the present writ petition is not maintainable since doctrine of constructive res judicata bars the same. In support of submission, so and so. The second contention as raised on behalf of KMC is section 171 and 176 have been amended upon incorporation of proviso to section 171(8)(a)(ii) and also upon incorporation of explanation 2 in section 176 with effect from 7th of August 2019. It has been contended that by incorporation of explanation 2 in section 176, the land in question needs to be assessed under section 174, and therefore the law laid down in favor is not attracted in this regard, so and so. The third contention made on behalf of KMC is the subject matter of challenge in the present writ petition is confined to mutation of the land in question, and the issue relating to assessment has been raised subsequently by filing a supplementary affidavit in the present writ petition. Therefore, in the present writ petition, this court ought not to enter into the question of assessment of the land as argued by the petitioners. In consideration of the submissions made on behalf of the respective parties, it appears that there is substance in the contention made on behalf of the petitioners that in the absence of any order of reversal, modification or affirmation passed by the Honorable Supreme Court upon invocation of the appellate jurisdiction, there is no fetter in relying upon the law laid down in February. While deciding the issue involved in this petition as to whether the assessment is to be made in terms of section 174(2) or 176, read with 171(8). In this regard, Kuna Ahmed is quoted. Then it has also been decided by the Honorable Division Bench in Niranjan Chatterjee that even an interim order of stay passed, I don't dispute these principles. Skipping over a few paragraphs, please take me to page number 16, internal page 11. In the present case, the land in question was leased out to the petitioners on 29th April 2013 by executing registered lease deed, wherein KMDA is the lessor. Therefore, considering the facts of the case, the methodology contained in the judgment of February relating to assessment of the land in question for the purpose of fixing annual valuation and property tax squarely applies in the present case. Though a feeble attempt has been made on the part of KMC to raise the technical point that the present writ petition is barred by constructive res judicata, but such argument does not hold much water in view of the fact that the previous writ petition was filed in the backdrop of license deed, which was executed on 23rd of July. Vide memo dated so and so, the KMC rejected the application of the petitioner on the ground that there was requirement of executing registered deed for transferring the land in question in favor of the petitioners. Challenging the same, the first writ petition being WPA 961 of 2012 was filed by the petitioners and the situation was changed since decision was taken by KMDA to execute the lease deeds in favor of the petitioners, which prompted the petitioners to have the first writ petition withdrawn. Subsequently, the present writ petition was filed, praying for mutation after completing assessment of the land in question for fixing annual valuation, and also challenge has been thrown to the memo dated 13 September 2013, whereby petitioners were insisted upon to pay tax as per assessment made by KMC. Therefore, at the time of instituting the first writ, that is WPA 961, the letter dated 13 September 2013 cannot be one of the issues, which is the subject matter of challenge in the subsequent writ petition. Therefore, the contention of KMC that it is a case where the principles of constructive res judicata applies is negative. The question of application of amendments made in section 171(8) as well as section 176 as discussed above pales into insignificance in view of the fact that such amendments were brought in with effect from 7th of August 2019. And in the present writ petition, the court is considering the assessment of the land in question with effect from second quarter 2010-11 and the validity of the letter dated 13th September 2013. It is straight law that retroactive operation of an amended provision is permissible when it has been expressly provided or by necessary implication. In the present case, in spite of posing query to the advocate representing KMC, no satisfactory answer is obtained whether, as per the relevant provisions of law, retroactive operation of the said amended provision is permissible or not. However, nothing has been found in the relevant provision which empowers the respondent authorities to apply the amended provisions retrospectively. Then, my Lord, Zail Singh is considered. I skip over those parts. Yes. Whatever is the pronunciation. Zail হবে না যেটা ইলি দিলাম exile then page 20. Upon such assessment to be made by the KMC, the decision to be intimated to the petitioners within 6 weeks from the date of communication of this order. After intimating the assessment made by the KMC as directed above to the petitioners, the petitioner shall be at liberty to make payment. Accordingly, the petitioners shall also be at liberty to renew its prayer for mutation of the land in question. Consequently, the previous assessment made by the concerned authority of the KMC with effect from second quarter 2010-11 stands set aside. However, it is made clear in view of furnishing undertaking on behalf of the petitioner as alluded above, the petitioner shall be liable to pay the additional tax based on the assessment if required to be made by KMC in terms of the order to be passed in the appeal pending before the Honorable Supreme Court. The concerned authority of KMC shall, if required, as per the order to be passed by the Honorable Supreme Court, intimate the petitioners the additional taxes required to be paid within 6 weeks from the date of passing order by the Honorable Supreme Court. And on receipt of the same, the petitioner shall pay the amount within 3 weeks thereafter. Then the writ petition is disposed of. The facts are very short. Your Lordship may kindly note a few dates, 4 or 5 dates. First is, on 14th of July 2010, KMDA, because the KMD was the owner, having control over the land, applies for mutation before the Kolkata Municipal Corporation, 14th of July 2010.
Yes.
6 days thereafter, that is, on 23rd of July 2010, the license was granted by KMDA in favor of the writ petitioners. 23rd July 2010.
Yes.
Then 13th of June 2011, is the response of KMC
Yes.
intimating that without a registered indenture, there can be no mutation. This was the KMC stand on 13th of June 2011. Then 29th of May 2012, KMDA executes a registered lease deed in favor of Medinet. Previously, it was a license in favor of Medinet. Now, it is transformed into a lease deed. Oh, I'm so sorry. I'm so sorry. I'm so sorry, 29th of May 2012, state transfers it to
you, to the KMD.
To KMDA.
KMD.
Yes. This is 29th of May 2012. Well, 11 months thereafter, on 29th of April 2013, KMDA executes the lease deed in favor of Medinet.
Yes.
Then 13th of September 2013,
Yes.
KMC claims the outstanding tax for the purpose of mutation from Medinet.
Yes.
This 13th May, document was challenged in WPA 961 of 20. No, sorry. Well, please give me a moment. WPA 961 এর prayer কি ছিল? Nine 961 of 2012 prayer গুলো দেখো তো।
Please see page 11 of the judgment.
Yes. But I just wanted to ensure, what was challenged in 961.
So therefore, page 11 of the judgment,
Yes,
please
yes.
have a, maybe it will clarify.
Challenging the same, yes. I think 13th of June 2011 was challenged in
Yes,
WPA
that was a
961.
rejection of some application.
Right, right. 13th of June 2011. This was challenged, my lord, in
961.
961 of 2012. My lord, WPA 961 was withdrawn on 9th of April 2013.
That was in the earlier status.
Earlier status, license status.
License status.
Now, my lord, the subsequent or the present writ petition was filed. Now, in the present writ petition, my lord, a supplementary affidavit was filed. And first, my lord, kindly now take, my lord, the praise in the present writ petition, which my lords will find, my lord, at page 29. The writ petition was primarily, my lord, related to, my lord, mutation. May I place the prayers? Prayer A is mandamus commanding so and so to forthwith accept, process and dispose of the application for mutation of your petitioner number 1 on the basis of the registered deed of lease dated 29th April 2013 without insisting upon payment of any sum on the basis of the purported annual valuation with effect from second quarter 2010-11. Then where the next pair is pair B mandamus to so and so revoke the purported letter dated 13th of September 2013. Then prayer C is certiorari, etc. Now, in this writ petition, my lord, a supplementary affidavit is filed. Where the supplementary affidavit, my lord, your lordships would find is at page 107. Now, here, my lord, the dimension of the entire case is shifted to, my lord, assessment. May I please take my page 114, that is internal page 8 of the supplementary affidavit. I therefore submit that this honorable court be pleased to hold that the purported assessment of the annual valuation pursuant to the hearing notice dated 5th May 2011 and all steps, actions and decisions taken and or made in pursuance thereof and all bills and or demands raised thereon are void and bad ab initio, and that your petitioner is not required to make payment of any amount based on such void assessment as a precondition for acceptance, consideration or disposal of the petitioner's application for mutation. Prayer A of the writ petition says that consider my mutation application without insisting upon payment pursuant to the valuation. This gets changed, Miller, at page 114, where they say that the annual valuation be declared void, which in my very respectful submission, Miller, cannot be done by way of a supplementary affidavit. Your lordships have, Miller, delivered judgments galore, saying that by supplementary affidavit, you cannot change the subject matter of the case. Miller, the remedy, as your lordships have always had, go for amendment. What important is?
Yes.
Now, my lord, the documents, my lord, if I can place one after the other. all these 5 or 6 minute dates that my lord I had mentioned. I will not trouble your lordship much with the pleadings and documents. First document is, my lord, at page 56.
You just give us a minute.
Okay, Bapita এসে গেছে? Okay. Yes, yes. Number only a few documents. Please take the first relevant document at page 56. Now, this is before the license was executed. But this is mere date, possibly where the entire date is not available, but it is 14th of July 2010. Now, this is being written by Millard, the KMDA to KMC. KMDA has been allotting bulk land to different institution business houses on long-term lease. As per procedure for residential plots, the registered lease deed is executed immediately. In case of bulk land plots, KMDA executes an unregistered deed of license with the allottee. This is done to allow the allottee to proceed with his mutation building plan work from KMC and to ascertain his seriousness. Only after the licensee has started actual construction work, lease deed is executed by KMDA. However, recently KMC has been disallowing mutation on such unregistered license deeds. It may be appreciated that every allottee has a stipulated time limit within which he must start construction, failing which he is subjected to penal action and his allotment is cancelled. With the mutation work being held up, the entire work of starting the project gets hampered. In these circumstances, you are requested to kindly allow mutation, building plan, etc. on all the license deeds executed by KMDA, and as it will ensure the smooth execution of all projects. So this is a general letter, Millard, not land specific. KMDA says that we are allotting lands, therefore you allow mutation. Then, Millard, the license deed is executed in favor of Medinet, which your lordships would find at page 45. This is dated 23rd of July 2010. But I'll not trouble your lordship with that. Now then, Millard, comes Millard, page 58. Pursuant to an application by Medinet, may your lordship take Millard the typed copy at page 58A.
Yes.
Millard, just beside serial number 11, your lordships would find that on the right hand side, this is the comment of KMC. Without registered indenture, mutation cannot be done as per Municipal Commissioner's order dated 9/3/2011. Hence, you are requested to submit a required indenture of your property with KMDA. Then, Millard, the next document is the state now transfers the land to KMDA. This year, lordships would find it at page 60.
Yes.
29th May 2012. Not very important for us. Then is, Millard, the lease deed that is executed in favor of Medinet by KMDA on 29th of April 2013. This, my lords, will find me out at page 87. Then, the 13th of September 2013 is at page 106A. It's at
Legible, it is not legible.
106 is a typed copy, my lords will find at 106A. That also not legible.
That is,
I'm so sorry.
there are blanks. The person who is typing it also cannot read.
Yeah, right. Yes.
And that may be relevant. We don't know.
Yes, absolutely.
That line which is missing in the second.
Yes, seems to be important.
Yes, therefore, yes.
You are liable to pay tax.
Pay tax.
There's something missing. I think it is something was there in handwriting or what? I don't know.
No, it is tight, but it is perhaps it is.
But I'll try to get a better copy for you, Lordship. তোমাদের পুরনো brief থেকে দেখো না। But I'll try to get a better copy. Will kindly note this page number, Milord?
Yes.
106.
Yes. You are liable to pay tax for
As on, my lord. I think it is as on.
As on.
Sure, my lord, but
tax
as on record.
Liable to pay tax.
as on, as per, what is it?
As on or as per.
So refer date.
Or referred date or referred rate? As per referred date, we don't know it.
No, it can be rate also.
Can be rate also, therefore.
Can be rate also.
Because we don't think there is any date referred in the previous paragraph. It's date.
But I'll get this. I'll try to get this.
Yes.
Then we'll are challenging this page 106.
Yes.
The previous. No, I think again I'm wrong.
Yes, this was put to challenge in the writ petition. This is their prayer B.
Yes. And we'll this writ petition 961 was withdrawn.
Yes.
This my lords will find me at page 162.
No. This was not withdrawn. No, challenge to this was not withdrawn. This is a challenge in the present writ petition.
Yes.
23/9/13 is challenged in the present writ petition.
Right.
Prayer B or C, something like that.
But your lordships are right, my lord. 13th September 2013 is
in the present writ petition. Prayer B.
Yes, prayer B. Right. At page 30.
Yes. Yes, 13/9/13, correct.
So the previous writ petition is withdrawn at page 162. And finally, my lord, we come to the present writ petition. Now, my lord, this is the background, my lord, under which, my lord, we are before your lordships, my lord, today. Now, my lord, I would place a few paragraphs, my lord, from the affidavit in opposition of KMC.
So this difference in the provision under which an assessment is made, it is amounts to a difference in the rate of taxation.
Yes. And my lord, not only rate of taxes, my lord, there was an amendment, my lord, to the KMC Act, by virtue of which, my lord, the taxation system itself underwent a change. Previously, now, my lord, with the amendment, the unit area assessment method of tax have been introduced.
No,
from 1st April 2017.
Since we have seen from the judgment of the learned single judge that whatever he has directed is subject to outcome of the SLP, then we are wondering why, how the KMC or KMDA will be agreed. That is what we are trying to understand.
Right.
That therefore we are asking you.
But my first, my lord, point of argument is made whether, my lord, in this writ petition, what would be the assessment procedure, whether, my lord, this could at all be gone into by the learned single judge. Because fundamental challenge was not to the method of assessment. Fundamental challenge was mutate without insisting this. My lord, could I come back on some other day? My lord, I've got a matter fixed at 12 minutes.
Yes.
When 9th, my lord, I think I've
8,
got a matter.
9, 10, 11, any date, you tell us.
Except 9. Before, after any day.
10th?
10th.
10th.
I'm grateful, my lord.
The kind of fixed up at 2 p.m. my lord. It was fixed at 2 p.m. my lord. Easily.
All right, at 2 p.m.
I'm so grateful.
On 10th, we have fixed a matter at 2 p.m. Item number 8.
Your Lordship, I'm led by Mr. Shoptang Shubhashulan.
Yes.
I'm led by Mr. Shoptang Shubhashulan, senior advocate.
Yes, yesterday, this is a matter which he was mentioning.
Yes,
So not today.
not today, Your Lordship. Monday it will. Great.
Item number 9.
Lord, item number 9 to 20, Mr. Mojumdar was addressing on the last occasion. He's engaged in some other court.
Not today.
Great.
Item number 21. Perhaps our chief's notification is likely to come to this good days. Opportunity of uploading. Amir called me last time. His chief will stop. He was very praiseworthy. First time. None appears. September. Item number 22. I never came out. My brother-in-law used to come here this very frequently, and Soman Mazumdar was assisting. That's what side. Now he's been also elevated last year. Last. Same out.
Item number 23.
I appear for the appeal. Yes, sir.
If you need a service.
There is no provision. There was no provision.
Terms of Regulation 45 confers power of a particular authority to initiate proceedings after retirement, provided number one, if he is suspended
Prior to his,
superannuation,
and it involves a loss.
and number two, if he is after superannuation, and 45(2) does not confer any power upon the authority concerned, but kindly have you look the regulation.
Let's see the regulation. Where is the regulation?
Page 56. An officer or employee
So it only talks of already existing proceeding, not initiation.
not in case, my lord. In this case, just 3 months before his retirement, 2 consecutive show cause notice was issued.
Show cause, not charge memo.
Not done. My lord, petitioner submitted his detailed rights to the show cause proceedings.
So no charge memo, no suspension.
No suspension, no charge before retirement. Petitioner retired from his service. Page 75.
Regulations, yes, sir. Even after retirement or some regulations, many regulations consistently you find here also in the central bank. It can be proceeded against even after but for an offense which relates only to from the secondly, it must involve laws to the employer. Cannot be.
But kindly have you look page 75.
Then you issue a notice, then we'll consider.
We have already sub notice, my lord. Day before yesterday.
You have filed an affidavit.
My supplementary affidavit I have filed after filing this writ petition.
No, your affidavit of service, have you filed it?
But last day before yesterday, learned friend appearing for.
Oh, he was appearing.
Yes, day before yesterday appeared.
Who is it? Ask him to come. If you know who he is, we can proceed. See, on 27 July, we directed for service of notice,
I served notice upon them.
but affidavit not filed. On last day, on 19/8, we don't find any appearance of anybody for the bank. There is only an appearance for you on your behalf. So therefore, if you know who is to appear, we'll adjourn it for the day. Ask him to be here on Monday.
I'll let it be taken up on Monday.
That's what we are saying. Not today. Not today.
Mr. Ghoshal, Bar Association Route number 6.
I know, man. Bajuju Ghoshal usually appears, but in this matter, Mr. Ghoshal is not appearing. Once
Normally appears on behalf of the bank.
Srimoy Mitro is appearing in this matter. And day before yesterday, when the matter was called on,
So why he has not given his appearance? Very simple issue is there. There is nothing.
it's very short and
Issue of jurisdiction, therefore alternative remedy may not be a bar.
it cannot be challenged until there is a jurisdiction. My lord, I have done. Regarding alternative Supreme Court says it is the rule of institution. It's a case where it is without jurisdiction with natural justice. On contrary to statute. Can it be taken up?
It will reach, don't worry. It will come on Monday.
Item number 24. Item number 24, I'm appearing, my lord, that CAPF matter, but my affidavit of service is not ready, my lord. Rather,
CAPF,
that height issue, my lord, 2D, my lord,
you are for the,
Appellate Union of India, my lord.
is there any delay?
Yes, my lord, 55 days delay, my lord. Otherwise, my lord.
Yes. Let's take it up.
1 week, my lord, next Friday, my lord.
For
Item number 20.
And for the bank, madam.
you were here day before yesterday when you did not file your appearance on that day.
I had instructed my junior probably.
No, the order sheet does not show.
And I'm appearing for the respondent, my lord. 24, my lord.
24 has been called. Yes.
3, my lord.
Let's see. And only an issue of jurisdiction is raised. Under 45, is there a provision for? No. Is there a provision under which a charge memo can be issued post retirement?
No, এটা 24 হচ্ছে তো। না 23 দেখাচ্ছে 24 my lord, the memo which is there, the rules which is there, that states that once it commences, then it can be construed that for that limited purpose, only for that limited purpose, as though he was in service post retirement. So once the allegation of defalcation, the excess sanction of loan, all that is there, and my lord, we have paid all.
So you are referring to 45.
Yes, my lord. 45, my lord. Page 58.
56.
Page 56.
56, my lord.
No, so therefore, you have to show us what is his date of superannuation.
That is 31st.
31st October 2020.
2024. So you have to show us that prior to 31st October 24, there was a suspension or there was a charge memo, either of the two.
My lord, on 28/10/2024, the charge memo was there.
Where is it?
Annexure P4, page 73.
So therefore, that is the start, the beginning of the process. Now, it does take time to realize that that person is at fault. He has done some defalcation, because my lordship is aware how the bank functions. Some officers do not discover such discrepancies. Some people do try to endeavor to discover. So therefore, this was there for sent to him on 28/10/2024. Then charge sheet was there on 4/2/2025. Charge sheet is annexure P8, page 81. And we have paid all his dues till date. Only one day, the increment for one day, one single day, I think it should be around 3,000, 4,000 rupees. That was awarded as a final punishment. Decrease in pay of one day. Otherwise, everything has been cleared by the bank.
So according to you, this 2810 is a charge memo.
My lord, that is the date when the disciplinary proceeding has been initiated. It has been discovered and we had to do something, so we have initiated the proceeding. Now, subsequently, the subsequent development is, admittedly, he had retired. But even if a person retires and before one day of his retirement, we discover something that he should be dealt with or punished or whatever, then should a bank which deals with public money sit tight over the issue? Admittedly, there has been certain faults on his part. We have issued him this disciplinary proceeding had started, according to my most humble submission, on 28/10/2024. Charge sheet was submitted on 4/2/2024, my lord. And final order was there on 13/3/2025. So we had to conclude the proceeding. And my lord, this service regulation 45(3), sub-rule 3, my lord, that says, if I may place it, the officer or employee against whom disciplinary proceeding has been initiated shall cease to be in service on the date of superannuation, but the disciplinary proceeding shall continue as if he was in service until the proceeding are concluded and final order is passed in respect thereof. So, therefore, my lord, the proceeding we had initiated and it has come to a final conclusion. All his payments, all his dues have been cleared, except one day increment has been withheld as a token of punishment.
One increment.
One day, yes, my lord, for one day.
No, one increment, 1 day.
One increment, that would be around 3,000, 4,000 rupees. Apart from that, everything has been cleared. And the appellate forum is, of course, there. So this is the best that we could have done. Admittedly, he had committed fault. Admittedly, he had committed defalcation.
He has admitted that he committed a fault.
My lord, we have come to a final finding, my lord.
It's your perception, not an admission.
All his dues have been cleared also, my lord. That is
here. Where is the punishment order?
Yes, my lord. The final order is
supplementary.
No, annexure P9, page 88. Dated 13/3/2025. Has the details, my lord, the statement of allegation, submissions recorded, and the final order, which is at internal page 90, my lord, the last paragraph. Reduction of basic pay by one stage lower in the time scale of pay which he belonged to as officer scale 3 with retention of FPP, POP, stagnation in increment, if any, and on conclusion of the date of the superannuation. Everything has been cleared thereafter, only that one day increment has been withheld. And the right to appeal is there as per provision 49, 50 and 51 of the service regulation.
Yes, that's all.
Hello, that's all. And I have some judgments also,
Sure.
which I may rely. My lord, one is that the quantum of punishment is within the domain of the disciplinary committee, my lord, of the employer. One judgment. My lord. Page 8, my lord.
No, but he is not saying anything about quantum of punishment.
Then, my lord,
not an issue. The issue is only whether he could have been proceeded against or not. That's the only thing. According to you, this letter of 28/10/24 is sufficient to invoke regulation 45. Whether it is sufficient to invoke regulation 45 or not, that is the only issue.
That is all we could have done. Suppose the person retires tomorrow. Today, I discover something wrong with that person. So, as a bank dealing with public money, is it not my duty to, my lord, I put this question to myself, to punish that gentleman if found guilty with a minimum punishment? This is not a maximum punishment, also.
Very well.
It's a minor punishment that we have imposed.
That's all.
Item number 25.
I've been instructed to appear on behalf of the private respondent.
This is one of those matters where the height was more than 169.5, but was less than 170, my lord.
There is a delay also.
There is no delay
No delay.
no delay, my lord.
How many petitioners?
My lord, read
One.
petitioner single.
Read petitioner
Male,
is-
male, 169.79.
The same order will be passed.
Similar orders, my lord. 27.
But only one thing I should brought to your lordship's notice. That is in the order itself, one paragraph your lordship's incorporated pending of review application before the Honorable Supreme Court. That review application ultimately dismissed. Well, that observation I think is not required.
So that will be deleted. The leave to the submission that the Union of India is.
I for the petitioner. There is a direction for filing opposition.
My lord, I am for the state, my lord. My lord, I have been newly engaged in this matter, my lord. I require some time to file an affidavit in opposition, my lord.
How much time we granted you earlier?
Only 2 weeks, my lord, granted by your lordships, my lord, on early occasion, my lord.
Insufficient. Time is insufficient.
Not insufficient, my lord. I have been newly engaged in this matter. I
And
have
what
laid
if
back-
before the next date someone else is appointed as a new lawyer? Then what do we do?
My lord, officially, my
Please, sir, you know that you have to file an opposition, you are supposed to do it. Just because you have come newly, therefore you should take 3
my
weeks.
lord, I am not on that, my lord. My
That's
lord.
what you are saying.
No, my
Because
lord.
I am newly appointed, so what? Before us is the state.
My lord,
Who is appearing is hardly relevant
I
for
am
us.
beseeching with your lordship, my lord. Kindly
Time
grant
for filing opposition is extended by 2 weeks from
2
date.
weeks, my lord. Great.
You wait. You wait. 27, 28, 29.
Take it 2 weeks. Date of 8th September. 8th September. But 27, 20.
Give it one by one. So single male petitioner,
Male petitioner.
My lord, my lord.
And
any delay.
Item number 28.
28 also, my lord, same. Here also single writ petitioner.
No delay.
Male.
No delay,
delay.
my lord. No delay, my lord.
So now why you are filing the appeals?
These were filed in February, my lord.
My lord, prior to coming my lord, order from the Honorable Supreme Court.
Furnishing words.
Can one see that? Appropriate. Can one to 25.
What is it?
Furnishing words being erroneous. Call for education.
What is the classification?
TST.
Appeal from its constitutional basis. Correct it.
But,
Correct it today.
I'm
The learned advocate
Item number 29.
But I'm the
29, my
applicant.
lord.
Similar matter, my lord.
They are also male candidate, single read petitioner.
No delay, my lord. There's no delay.
No defects. Same defect. Same order. Have patience, yes.
Item number 30.
Your respondent.
Yes, my lord. That one I was arguing on the last day, my lord.
Where is your counterpart?
I'm sorry, my lord.
Where is the appellant?
If the appellant is not there, my lord, can it be like posted on Tuesday? Monday, I'm not in Kolkata, my lord.
None appears. Last day also.
Item number 31.
My lord, this is my application, my lord. In this matter, my lord, I am appearing on behalf of the appellant, my lord. The last date, if your lordship can recapitulate, lordship. That retrial matter, lordship asks for the section 163. The last date.
AFT.
My lord, the Navy personnel, my lord.
Yes.
My lord, একটু সাইড দিন না।
The big paper union opinion.
আছে তো বাবা।
Where is the order of retrial?
My lord, page 112.
And the review is specified in which provision?
My lord,
Where is the power of review?
the review of the petition, my lord.
No, review by the
By the appellant, my lord.
by the authority.
As per the lordship, the novel order, my lord. As per the novel order,
You filed a review petition.
my lord, on the basis of the novel order.
Where is that?
My lord,
Review is filed under 163 only.
review lordship, I filed both, my lord, 162 and 163. But lordship, because they lordship they give me the opportunity whether you are tried by the court martial. On the basis of that, lordship, I review the petition on the basis of section 162 and 163.
What the tribunal has held
My lord, page 512.
Also, the retrial also concluded.
My lord, concluded, lord, dismiss me from the service. My lord, concluded during the pendency of the original application.
And you challenged it by way of miscellaneous application.
My lord, I challenge in the meantime, my lord, on the basis of that, because this order is unreasoned order, so this retrial, this order should be set aside. Lordship, on the basis of
Challenge it by a miscellaneous application.
application, Lordship.
The subsequent order also.
The
So there's two original application.
My lord, initially, Lordship, on the pendency of this application, Lordship, they provide this communication order, Lordship, that is page 113. That is the order they placed before the original, before the learned tribunal, but without giving me that copy also. But they said this is not the, this is a communication order. Thereafter, Lordship, after that next date, they said the learned tribunal made the observation that since they have give the copy, so now these original applicants become infructuous.
Oh, so you filed a fresh way.
I filed a fresh way, Lordship. In the meantime, Lordship, I asked for the stay of these retrial proceedings, but they said on the next date, my lord, we will take up that matter. But the issue is that after that, my lord, the tribunal was not functioning because of the want of quorum. On the basis of that, my lord, I challenge this matter before the. I actually want to invoke Article 226. Also, Lordship, they raised the maintainability issue.
So where is the way which has been considered by the learned single judge? Prayer in the way.
My lord, only prayer portion, my lord.
Yes. 89.
My lord, page 70, my lord. My lord, that is a read petition, my lord.
'89.
Just consider page 89.
My lord, page 89. May I place, my lord?
This is the current way.
My lord, this is the current way. Way number 112. My lord, 119. 119.
So you did not challenge the subsequent order.
My lord, subsequent order, my lord, after that, my lord, I filed a dismissal order before the writ court, my lord. After, my lord, the infructuous, the writ, my lord, after the dispose of this matter, my lord, I filed this original application.
Can you understand? This is the first OA or this is the second OA?
My lord, this is the. My lord, this is the second way, my lord. The second one or first one?
Maybe not.
My lord, this is the second way, my lord.
But you did not challenge the final order passed in the proceeding.
Well, after, my lord, during the midst of these proceedings, my lord, they dismissed me. My lord, it is already mentioned in this order, my lord.
Just now you told us that you filed the OA, that retrial is not permissible.
My lord.
During pendency, the dismissal or whatever came, then you had to file a fresh OA. So in the fresh OA, that means you would have included the order passed by the court martial. But where is the prayer for setting aside the court martial proceeding?
My lord, after that, my lord, I filed a miscellaneous application, page 137.
We asked you whether you have filed MA, you said no in the subsequent.
No, my lord, miscellaneous application only for the dismissal, for the stay of the dismissal from the service.
Correct, 130.
My lord, page 123.
The same. You are appearing for the Union of India. You are for the Union of India.
Yes, Your Lordship. I'm being led by Mr. Ajay Chaubey. He's appearing.
My lord, I'm also appearing, my lord.
Yes.
My lord. Well,
My lord, may I submit for a moment, Lordship?
Yes, we'll fix a date for final hearing of the matter.
Monday, my lord.
No, after 2 weeks.
Yes,
My lord,
the officers are required to bring the records from Visakhapatnam minor. 2 weeks is required, my lord.
my lord,
What
may I-
records? Entire records?
my lord, my humble submission before your lordship in this matter, my lord, the record has been placed before the learned single judge, my lord. But that is not the part of the pleadings, my lord. That is my entire submission before your lordship. Some of the on the basis of some internal records, my lord, and that is part of this impugned order, my lord. That is not the part of it is not the part of this our pleadings. And lordship, my humble submissions, initially, my lord, once I filed this original application, I only challenge this withdrawal order, 13 February 2024. It is unreasoned order. So on the basis of that, this withdrawal should be set aside. This is the facts and first and foremost of this original application. In the midst of this original application, my lord, they dismissed me from the service.
So this subsequent event is already on record. So we'll have to consider everything.
My lord.
Can't be confined only to a retrial.
My lord, may I, indulgence for my lordship, give some precedence, some over.
You raised an issue of malafide against the person who was conducting the earlier court martial.
My lord, it is not the court martial matter, my lord.
The first trial was conducted by which captain?
By my lord, the Joydeep Mukherjee.
So you allege malafide against him?
No, my lord.
No.
No. Lordship, since I don't even know under which provision, whether there is any provision for the conducting of the retrial. So my only contention regarding this.
Please answer what we ask you. Saying the same thing again and again, that is not helping you. We are asking you, a trial was conducted. Thereafter, according to you, unreasoned order was passed for retrial. Now this, prior to passing of the unreasoned order for retrial, you challenge the trial. On what grounds?
Since the unreasoned order, I don't know the reason. This is the Lordship, under which provision? This is the reason whether I filed this original application. The either Lordship, this order has been permissible on the basis of this.
Why did you file a review before the authority? Why did you
before
file?
the Lordship, that has been agreed by the punishment, my lord, not before the.
So what grounds you are challenging? That's what we are asking you. You are stuck on retrial. We are asking you on what grounds you challenge the first finding.
That punishment is not permissible, Lordship. That punishment was not permissible. That
the punishment.
The punishment will also be reduced to rank me, and the repayment by the captain and stoppage of my salaries, so 60 days pay, and Lordship, and also the stoppage of my first and second good conduct batches. That was the punishment.
So
that punishment, Lordship would challenge this punishment.
What ground? That's what we are asking you. Have alleged some procedural irregularity?
My lord, that was, yes.
What? Tell us the points we are asking you. What on
My
what
lord,
ground?
this Lordship, since my lord, that is not the subject matter, Lordship. Only Lordship, I have annexed this review petition, petition, page 523. That is Lordship only annexed. This entire facts, Lordship, that is not with me.
So if we set aside the retrial order, then what happens?
My lord,
please tell us.
Yes.
What will happen? That's punishment will revive. What are you submitting?
My lord, my submission.
What relief you will get? You are stuck on this retrial that is without reason. If we set it aside, then what happens? Your punishment is revived.
Back to the.
All the punishment that you are saying is revived.
Yes. Well, that Lordship, I have challenged Lordship. That has already been challenged.
Therefore, we are asking on what grounds you are saying I have not done anything. I am only confined.
My lord, not Lordship. Lordship, in my first original application, Lordship, I have taken all these points.
No, that original application is over.
My lord, in this original application,
that is over.
First original application, that was Lordship disposed
That is over. That cannot be considered by any forum today.
My lord, that only that at this moment, my lord, this or that original application, Lordship, only I.
Madam, that is why we are asking you. You are raising academic issues or you are raising issue for relief.
My lord, relief, my lord, relief.
What relief? The retrial order is without reason. Set it aside. All the punishment revised.
My lord,
Then
if
what
that
happens?
be so, my lord, if that be so, my lord, this reduced rank, Lordship, only for the 1 year, my lord.
If that be so, if this be, we are not here for bargaining.
No, my
We are
lord,
trying to see.
Lordship, for a moment, Lordship.
We are trying to see how you have made out a case.
My lord.
We have gone through it.
My lord,
Then we
that
are making something.
punishment, as your Lordship said, what is fallen?
In your, the only fear is that the retrial order is not sustainable.
My lord. My lord, the punishment, as your Lordship
Your only relief is that the retrial punishment is not, retrial is not permissible. So, okay, then no retrial. Then you face all the punishment.
My lord, may I submit that? My lord, initially, Lordship, there are 4 charges. After, Lordship, 1 year, my lord, they retrial.
You have not assailed those things in the way how we can go into. We are trying to understand how to go about the case. You are jumping from one point to the other.
My lord,
The fact remains that you were proceeded against. In the proceeding, a series of punishment was inflicted. You use the opportunity available under 162 to write to the central government or the naval chief staff.
Naval chief.
And that opportunity was availed by you. Pursuant to that opportunity, the chief of naval staff directed that let a retrial be done. You say it is without jurisdiction, you challenge it. If we set it aside, what do you get?
My lord, now what is fallen from your Lordship? If Lordship, for a moment, if that order, if your Lordship's order is in my favor, that means Lordship, I again came to back to the previous one. Lordship, that reduced rank, that was the previous charges, my lord, reduced to rank, stoppage of salary.
Yes,
My lord, that reduced to rank the stoppage of salary, lordship, that is.
there is a reduction of pay, there is a reduction of rank, everything is there.
Yes.
So you are satisfied with that punishment?
My lord, yes. Lord, for that reduced to rank, my lord, that is only for 1 year.
No.
So that is, lordship, my point is.
You need not justify. We are saying you are satisfied with that.
I am satisfied.
Then say that. That's
See,
what we
I
are
am
asking you.
satisfied. I am not on that because I have already imposed that punishment, lordship. I have already imposed that punishment.
Very well. Then we'll consider.
Lordship,
The learned
written
advocates
some.
are appeal.
That one more India should preferably on top, my lord, if subject to lordships.
Let it come, yes. Huh?
14.9.
Okay.
Great for you, actually. So this
Item number 32.
Lordship, as per the direction on the previous day, I have served upon the writ petitioners. This is the affidavit of service.
This is where the Public Service Commission is the actual answering respondent.
Who is
and
the actual answer?
The PSC, the Public Service Commission. Lordship, this is relating to a selection process. Lordship, there was a direction for filing of affidavit in opposition to the application for condonation of delay. Lordship, our instructions are we have not filed because it's the main answering respondent is the PSC and it's up to them. That is what we have been instructed to do. So
So
therefore,
PSC now has been served.
Yes.
Shows.
I have already submitted the affidavit of service on the first day, on the previous day, Your Lordship.
Who is appearing for Public Service Commission?
No one appeared, Your Lordship.
Why don't you intimate the learned advocate who has appeared?
Pardon, Your Lordship.
Why don't you intimate the learned advocate who appeared?
orderটা দেখে দিয়ে দাও
23rd April 2020.
Lordship, they must be following up the matter. I never seen.
Very well.
They have not filed on the last day. No, we are not filing. It's our instructions are on the PSC.
When the affidavit of, when you served it?
After filing this appeal, Your Lordship, it's a long back. They appeared on first.
That is why we are saying this is prior to reconstitution of the entire panel and everything. This is of May. 4th to 7th May 2026. After that, in the last week of May, 20th or 25th, something like that, the new panel has come. You have an option either to inform, because perhaps that learned advocate will now be appearing. All the panels have changed. Therefore, we have to ensure that somebody is represented.
That may be the reason, Your Lordship. On one day they had appeared. Later on.
So it is better to serve directly to the office instead of
service notice of the learned
Let
advocate.
there be a service, then we'll
Then we
proceed.
can take it up.
Yes.
It's September.
33.
My lord.
Never, never.
My lord, item 33.
You are appearing. In this case,
My lord, item 33, my lord, I'm praying for not this week, my lord.
why, madam? No.
My lord, this is a no objection brief, my lord.
So?
We have received the brief before 2 days.
Then why you are not ready if you have received it? Why it is to be adjourned? If you have received it, you are here to argue.
Monday, my lord.
Not today. Come on Monday. Let's see. Better come on. Let's see. Yes, just a minute. How much delay? Yes. You filed an application
My lord.
for condonation.
No, my lord, I'm stay application, my lord.
Stay without condonation.
My lord, later some time, my lord, I will.
Huh?
Yeah.
There is 1 day delay in filing the appeal.
My lord,
Reported by the stamp reporter.
My lord, let me take some time.
As prayed by the learned advocate for the appellant.
After the year. 8 September. Condonation application filed.
34.
34, my lord, I am for the petition in this matter. This is my individual service.
34 is my matter. Biswajit Bhagan.
Oh.
34. 34 I am for the appellant lordship.
Lord, I am for the private respondent petitioner.
Lordship, there was a defect, Lordship, to file certified copies, Lordship. We have already applied for the certified copies. We are waiting to get that certified copy so that, Lordship.
Certified copy of which forum? The learned single judge order.
Lordship, single bench order.
My lord,
You have not got it.
No, Lordship, we have not received that.
The order passed by the learned single just 2 appeal was preferred. One is this is the appellate authority and another is the Union of India. Union of India's appeal has already been your lordship's disposed it of. Now this appellate authority's order is appeal is pending. Due to non-supply of certified copy of the order, it is just pending.
What is the issue?
Issue is that the same. That is the rounding of
169.
Lordship, height
issue.
Then what?
Well, only for the supply of certified copy.
The copy.
We have applied and contempt is pending, Lordship. That is why it may have been taking time to get that file.
আপনি pray করতে পারেন। তাও একবার বলে দিচ্ছি তো একবার বলে দেখি কি বলে। তো আইসে দিয়ে দেবো। I think your lordship, if your lordship give the leave to the appellant to move this matter on the basis of the server copy, then the matter can be disposed of. Otherwise,
In the other case, certified copy was filed.
that is
In
that was
other
fine.
cases,
In
lordship,
that
certificate, we
certificate
received the certified copy, but there was a correction order, lordship.
Oh.
And that correction order certified copy we have not received, and that is why we prayed for the leave to file that copy, file the application, lordship. And after the granting of leave, lordship, we filed this application, but certified copy needs to be filed. That is the main issue, and we have applied for the same.
So what change do you expect in the coming week?
Lordship, this situation, lordship, the contempt petition is also pending, and the file is in
That's
that.
why we
contempt.
are saying what change do you expect? You have to take steps
Lordship, we
for obtaining the
lordship, we
copy.
will-
Unless you take steps, the contempt will be pending.
Lordship, we will pursue with the register.
Yes,
Lordship, or
you know how to do it.
Lordship, we will. Lordship, we will. Or Lordship may also give a direction to the register if that is upon Lordship law. If to
That's why we said you know how to do it.
Lordship, we will.
Yes, we are not required to pass any order. You know how to do it.
Lordship.
If the file is pending somewhere, what are you to do? Where you have to mention everything you know.
Very well, Lordship. We will.
The
First wife and second wife was directed by the lordship to be present in the court today. The first wife and second wife is directed by your lordship to be present in the court. Ask them to wait for a while.
My lord.
Yes. 3 PM we will go that some chamber at 3 PM. 3 PM.
If the learned
Let's see what happens.
Item number 60. It's my appeal, my lord. That FCI appeal, my lord, I will, since my lord, Justice Ray has I will take today and another day, my lord. I will exhaustively argue this matter, my lord.
Oh, this composition didn't, this bench composition did not consider it on the earlier day.
No. But I would argue, because this is the current bench, I would like to argue, and I would like to argue threadbare, my lord. There are some documents that I would like to show, my lord.
So the last argument?
That argument is there. I'm not disputing on that. I will base my argument on that only.
How that argument is there, that is what we are asking you.
Let kindly hear it afresh.
Afresh,
It was
afresh.
not marked as a partner. It was never marked as a partner.
Never marked. I will start from the beginning then, my lord. I'll start from the beginning. I intend to start from the beginning because
What we have been following till now, we are just letting you know, in all such matters, 3 or 4 matters came up which were not part-heard, but considerably, taken up on an earlier
it
date.
was only taken up once, my lord, and I took accommodation.
I
from the
remember
bench.
you were saying there are different class of employees and
Yes,
therefore
yes.
they
But
cannot-
why it is a different class, I will explain, my lord, with law and, my lord, with the documents available, my lord, and the statute that is available, my lord.
Kindly take it up.
Yeah, very well. Which is?
Otherwise it keeps slipping.
May I?
Yes, please.
Prior to, my lord, taking to your lordship to the relevant documents, my lord, how, my lord, we had, my lord, prior to, my lord, establish our case, my lord. Let me enumerate that first, my lord, and thereafter, my lord, I will take your lordship to the statute and how the statute is applicable to the current context of the matter, my lord. Lordship will kindly take, my lord, first, my lord, page 276, my lord, sorry, page 225. That would be, my lord, volume 2 of, my lord, the paper book, my lord. This is my affidavit in opposition, my lord. I will start from here because, my lord, my entire case factually deals, my lord, with আমার affidavit. হ্যাঁ, সেখান থেকে করবো।
আমি আমার অ্যাফিডেভিটটা পড়াবো 225 220
Give us 5 minutes.
yes my lord. It's 225 by the way, the page probably.
Where is 9 ABC?
Yes,
Page 69. Page 69.
page 69 my lord. That is the statute, but I will come to that a little later my lord. Let me my lord show from the
Yes, you make your submission.
yes my lord. 9 ABC on the last occasion I did my lord mention my lord. ওখান দিয়ে শুরু করছি Lordship will kindly take at page 229 of my affidavit. Sorry. Very sorry, my lord.
Yes. Yes.
Grateful, my lord. I would, my lord, place reliance on page 229 of my affidavit in opposition of the paper book, my lord, which is my affidavit in opposition to the original writ petition, my lord. When the writ petition was filed, my lord, I will take your lordship to the prayers of the writ petition after, my lord. Let me, my lord, after placing the pleadings, certain paragraphs, my lord, which would, my lord, then, my lord, I will take your lordship to the statutory provisions and the agreement, my lord, how the flow of events, my lord, led to this, my lord, litigation, my lord. Paragraph 4, my lord. I say that the respondent number 1 is a statutory body constituted under the Food Corporation Act 1964, and its employees are guided by the FCI staff regulation of 1971. But will kindly mark these statutes because these are extremely relevant for the purpose of really going to the root of the matter as to why these regulations are relevant and how it is applicable in our case, my lord. Apart from the said regulation, no other guideline exists to frame any additional specification and or benefit for the staff so employed. I say that the benefits of 64 of the liberalized pension scheme of the food transferees has been granted by the central government as per the statutory provisions provided under section 12A of the Food Corporations Act 1964. This is the amended provision, my lord, that came in, hereinafter referred to as the said act. No provision for the deputationist exists under the said act to extend such benefits to the deputationist and to the direct recruits of the respondent number 1. In the absence of any such provisions, the benefits of the liberalized pension scheme cannot be extended to such deputationists who were absorbed as direct recruits. The said act has been amended by the legislature to extend the benefits of such liberalized pension scheme to the food transferees who did not have the option to be repatriated to the central government and were left with no other option than to be transferred to the respondent number 1 under compulsion. Such power to amend the said act and make directions accordingly lies with the central government, and as such the government of India will be the sole authority to adjudicate the matter appropriately. Next paragraph, my lord, it is extremely interesting, my lord. In this connection, it is pertinent to mention herein that there are three classes of employees, which Millard on the first day when I started my submissions, Millard opened my arguments, Millard, Millard specified there are three classes. Lordship will kindly bear this in mind, Millard, when Lordship, when I read through the lines, Millard. First is food transferees, that is the employees of the food department of the central government, transferred to the Food Corporation of India on compulsion, having no other option for being retained with the central government. And such food transferees are getting the benefits of the liberalized pension scheme of the central government as per the provisions of the Food Corporations Act 1964. This category is, Mr. Millard, senior friends, clients, the state government employees, the deputationist. The deputationist from the government of West Bengal had been absorbed as direct recruits, having options to be repatriated to the state of West Bengal if they found that the terms of absorption with the respondent number one not suitable for them. The said deputationists were absorbed as direct recruits and are drawing the benefits of pro rata pension and commuted pension from the state of West Bengal in addition to the Sangma pension under the employee scheme of 1995 with contributory provident fund. I say in this regard that out of 5,000 deputations, around 2,100 opted for the absorption and rest got repatriated to the government of West Bengal. Pausing here for a moment, Mother, there was an option form given to them. So they who exercised that option were taken as Miller direct recruit, as we say, under the, and people who did not exercise that option remained back with the with the state government, Miller. Three, the direct recruits who had been recruited, the direct recruits who had been recruited by the respondent number one after due selection. This is when the FCI gives advertisements, recruitments happen, exam, viva and everything. This is the third category. In the above context, it is pertinent that all these classes arise out of the method of the recruitment with the respondent number one, and all of them are regulated and come within the purview of the FCI Staff Regulation 1971. It is further pertinent to note that Article 14 million provides for reasonable classification and does not insist that the legislative classification should be scientifically perfect or logically complete, as held by the Apex Court. The difference with which will warrant a reasonable classification need not be great. What is required is that it must be real and substantial and must bear some reasonable relation to object the legislation. When a law is challenged as denying equal protection, the question for determination by the court is not whether it has resulted in equality, but whether there is some difference which bears a just and reasonable relation to the object of the legislation. Mere differentiation or inequality of treatment does not per se amount to discrimination within the inhibition of the Equal Protection Clause, my lord. For a moment, my lord, thereafter, a subsequent amendment that was brought up, nobody challenged. So that amendment was brought, that 9A, B, and C, which Lordship rightly had pointed out, I will come to that, Miller. That only happened sections and provisions in the regulations were on the basis of the recommendation by the government, on the basis of that recommendation and carried out. Category and the first have or have challenged them because this is creating an equality amongst equals. Inequality amongst equals. Example. That the person for that is fully aware that once he opts for a A, so this is the distinction. But I will thereafter, I will skip. I'm sorry. আমি বলবো তো আমি জাস্ট আমার এখানে যেটা বলছি সেটা বলে দিচ্ছি I will not trouble your lordship. This is basically the matrix, thereafter I will straight away lordship take your lordship to paragraph 18 at page 236. I'm skipping the earlier paragraphs. There are denial, dispute, etc. But 18 is essential, I'm skipping the first 3 lines, I'm starting from in this connection. In this connection, we say that absorbed as direct recruitments so the state circular 4, their services were guided by Food Corporation of India Staff Regulation 7. I further say that the writ petitioners were short PPF scheme under the Food Corporation of India Regulation 67 and got the entire settled for the equal contribution by the responding authorities contribution. CPF regulation, the petitioner along with other members said CPF were stroke are entitled to the Employees Pension Scheme 1995 only like other direct recruitees and not any scheme not specified under the State Food Corporation of India Staff Regulation 71. CPF regulation of 1967. In any event, the writ petitioners are taking recourse to enjoying double benefits by way of suppressing the material fact that they are already drawing a pension from the government of West Bengal in respect of the service rendered by them with the state government, and now even expiry of the prescribed period, they are also getting restoration of the commuted portion of the pension from the state government. So this was again categorically clarified that how it should be computed. You cannot, in my respectful submission, get benefit from 2 different places once you have opted for one. Now, straight away, lordship, will not trouble your lordship much, I will straight away take your lordship to the supplementary affidavit that was filed by us. That would be at page 276. That should be the same volume. This supplementary affidavit was filed by us pursuant to an order of this Honorable Court dated 11th of April 2013. Yes. Let paragraph 3 onwards, when this Honorable Court, was pleased to file, in fact, we filed 2 supplementary affidavits. The first, And the second one, again pursuant to subsequent order in 2029, when we filed the second supplementary affidavit, which I will again place. After this is the factual matrix, then I will take your lordship to the legal aspect of it. I say that the effect of a transfer under 12A, section 12A of the Food Corporations Act is that the employee concerned ceases to be an employee of the central government and becomes an employee of the Food Corporation of India with all their existing benefits being enjoyed by them with the central government, including those under the CCS pension rules. In the case of the state government deputy, I have my lord's screen. In the case, the state government deputationist who observed as the respective direct recruits, they having served their lien with the state government do not come under purview of such CCS scheme pension rules. I further say that the date of absorption of the deputationist at direct recruits with the Food Corporation of India as 1st of July 1984 was not individual but applicable to all the deputationists. More so, the food transferees have no option but to opt out from the Employees Provident Fund scheme and were enjoying the General Provident Fund scheme, whereby they were not subject to contribute to the family pension scheme and consequently not entitled to the Employees Provident Fund scheme, which is generally called the Sangma pension. Only the employees under the Contributory Provident Fund scheme in any organization throughout India are compulsorily obliged to contribute to the Employees Provident Fund and entitled to the Employees Provident Fund pension. In addition to the above, in clause 2 of the option undertaken by the deputationist under circular 21 of 1984, the deputationist have categorically undertaken that they on the option agree to be treated as direct recruits and be made a member of the contributory provident fund under the FCI CPF regulation of 1971. So moment I opt for this, I cannot have that. So this was our argument and our stand throughout. Now paragraph 5, I can skip. Paragraph 6 is very important. Paragraph 6 will there's a chart that we had compiled. In strict compliance with the direction of the order dated 11th of April 2013, passed by this honorable court, I append herein below comparative chart indicating the status of the respective food transferees and deputationists. Comparison. This perhaps will enlighten the entire cloud that possibly has been casted over the status of the writ petitioners vis-a-vis the status of the central government employees as well as the direct recruits of FCI. Kindly, Lordship will kindly see central government food transferee, the first column. Pay scale determined by the government of India as recommended by the Central Pay Commission for time to time. Now, the second column says directly recruited observed West Bengal deputationist. That is, pay scale determined by FCI as agreed upon in bipartite agreement. The agreement mentioning on the first day of the 64 agreement, duly approved by the concerned ministries, government of India.
This status which you have laid out in the table.
I'm sorry, Millard.
This status which you have laid out in the table,
yes,
it is a status prior to their coming here or after their coming?
After. Now, Millard, enjoying DA pattern, again, central government of government of India enjoy DA pattern of the IDA based on IACPI. Then, my lord, enjoying general provident fund, enjoying contributory provident. I'm sorry, my lord. So this is post. But I'm grateful, Mr. Chakraborty. Well, status was prior. Once they come in, this categorization happened once they came in, Millard. Not a prior status, Millard.
So
Once they opt,
therefore, in serial 2,
yes,
when you say enjoying DA pattern of IDA based on AICPI, this is what they are getting in the corporation.
yes, yes. And they have opted. It is not that they had an option not to come to us.
No, that you have already said, yes.
Now, Millard, I will straight away, Lordship, Lordship will kindly take the third volume once, Millard. The second supplementary affidavit, Millard.
So the procurement and procurement, storage and distribution of the state government was also taken over totally by the FCA.
I will have to take it. It was taken and then it was given back. That's my instruction, Millard.
No, but this is at the time of the exercise of taking over.
Yes, yes, precisely. That's perhaps the situation was. Millard, I
Third supplementary is at second supplementary is
at page 316, Millard. That would be the other volume 3. Yes, Millard. I'm sorry, Millard. There are 5 volumes, Millard. Is third volume I would refer, Millard. Earlier there was not this volume thing. We used to get like big fat ones, Millard, and it was difficult to maneuver at that time, Millard. I will only, Millard, place Millard, paragraph 5 onwards, Millard. 2 paragraphs I will place, Millard, and the sub paragraphs, Millard. FCI came into existence in 1965 by virtue of the Act of 64. In the said Act, there was a special provision under Section 12A of the Act for the transfer of central government employees to the FCI in certain case. So 12A, Millard, only concerns, Millard, the transfer of the central government employees and nobody else, Millard. So nobody, by even figment of their imagination, come within the purview or the cloth of 12A if he or she is not an employee under the central government, Millard. No other employee. Even the direct recruits also cannot come in, Millard. It's so specific, Millard. Accordingly, services of some of the employees from the Department of Food, Government of India was transferred to the FCI. Such transfer was mandatory, but such central government employees had the option to exercise in writing to be governed by A, the scale of pay applicable to the post held by him under the government, that is the previous employer, that is the central government, Millard, immediately before the date of transfer, or by the scale of applicable to the post under the corporation of which he has been transferred. So the option under 12A was given only exclusively to the central government employees, whether they wanted to retain their on the very day till the day before the day of their actual transfer, or they want to get absorbed under, Millard, the FCI's pay scale, Millard. So that option was already given to them, Millard. Second is very important, my lord. The leave, provident fund, retirement or other terminal benefits admissible to the employees of the central government in accordance with the rules and orders of the central government as amended from time to time, or the leave, provident fund or other terminal benefits admissible to the employees of corporation under the regulation made by the corporation under this act, and such option once exercised shall be final. So if for the central government, although the writ petitioners are not central government employees, why I am placing emphasis on this, my lord? Because the state government employees also had that choice of exercise, my lord, and they could not have come within the purview of 12A. What they say they can is not, because by the virtue of the act and the scheme of and the rigors of section 12A of the Food Corporation of India, also read with the staff regulation, which I will come a little later, my lord.
So both had an option, whereas Government of India had an option to elect the service conditions. They had an option either to come or not to come.
Yes, precisely. I'm so grateful. So grateful, my lord. So grateful. May I, my lord, place, I'm grateful, my lord, may I place 12A once, my lord. Again, I'm grateful to Mr. Chakraborty. So, the golden rule of interpretation of a statute, Millet, if the legislature in its wisdom, Millet, they carve out, Millet, certain words to be placed in a certain manner in a particular statute. Millet, it is another view can be taken out of the word, it has to be given its literal meaning. Now, section 12A, Lordship has the FCI Act, Millet? 12A I'm placing, Millet. Special provisions for transfer of government employees to the corporation in certain cases. The section opens with where the central government has ceases to perform any functions which under section 13 are functions of the corporation, it shall be lawful for the central government to transfer by order and with effect from such date or dates, which may be either retrospective or to any date not earlier than 1st of January 1965 or prospective, bracket close, as may be specified in the order of any of the officers or employees serving in the department of the central government dealing with food or any of its subordinate or attached officers and engaged in the performance of those functions, provided that no order under this subsection shall be made in relation to any officer or employee in such department or office who has, in respect of the proposal of the central government to transfer such officer or employee to corporation, intimated within such time as may be specified in this behalf by that government his intention of not becoming an employee of the corporation. But I will skip 2, 3. I will come to 4.
4 is precisely what you read just now in paragraph 5 of the supplementary act.
Yes. Grateful, Milad. Now, Milad, the provisos also is interesting, Milad, which is not there in paragraph 5, Milad. Let me place the provisos also, Milad. Provided that the option exercised under clause A shall be applicable only in respect of the post to which such officer or employee is transferred to the corporation, and on appointment to a higher post under the corporation, he shall be eligible only for the scale of pay applicable to such higher post. We are not concerned with that. 8 or 4, 8 or 4, 4.
circular 20.
Sorry.
So the two provisos read together, perhaps you're trying to say that the exclusivity is there in the act itself.
Again, I will read 4A after this, which will make it even more clearer. Provided further that immediately before the date of his transfer, any such officer or employee is officiating in a higher post under the government, either in a leave vacancy or in any vacancy of a specified duration, his transfer shall be protected for the vacancy. So he shall be entitled to the scale of pay. Again, I am not concerned with that, Millard. I am more concerned, Millard, with 4A, Millard. These are the provisos only based on the scale of pay. I am on the retirement benefits and contributory CPF and, Millard, the other provident fund provisions, Millard, of the central government, Millard. 4A, notwithstanding, it starts with a non-obstante clause, Millard. Anything contained in subsection 4. Every officer, that's A, or other transfer under subsection 1 had been made before the commencement of the Food Corporations Amendment Act of 1977 shall, whether or not he has exercised the option under section 4 before the exercise such option within 6 months from the appointed day. So some persons actually, if they missed the bus earlier, this section gave them a second option to exercise, and again, second opportunity, but restricted to central government and no other persons, Millard. Not even the direct recruitees, Millard. Direct recruits. B, officer or employee and subsection 1 appointed shall within 6 months from the date of such order exercise his option under subsection 4. And in each such case, such option once exercised shall be final. Provided that where an officer, Millard, I do not, Millard, this is not really relevant. So I restrict myself till here. Millard. Now, what the repetitions, Millard, are trying to say, Millard, is that the provisions get that option themselves. The pensionary benefit, the second part, Millard, precisely, Millard. Grateful, Millard. Now, Millard, may I? Now, Millard, paragraph 6, Millard, I should come back, Millard. আমার 316 319 করছি। It is submitted that with regard to the state government employees, an agreement, what I mentioned the agreement on the very first day when I argued, Millard, I opened my submission, Millard, dated 26/11/1966, was entered in between the government of West Bengal and FCI for the purpose of regulating the deputation service of the state government employees and approximately 5,000 employees from the Food and Supplies Department of Government of West Bengal were on deputation to the Food Corporation of India, and the deputationists were regulated by the terms of the agreement as entered on 26/11/2066, and nobody, but there is no dispute with regard to this because this agreement did existed at that point of time, and by the date of this agreement only, Millard. 7, Millard, options were invited in the prescribed pro forma. Now, this option, the pro forma, is different from the pro forma central government under 12A. Now, perhaps, Milord, it is the endeavor of the repetition, or rather it was the endeavor of the repetition, say that the pro forma that was prescribed, pro forma that was given by the date of the agreement of 66 and circular number 21 exercising option under government. They are trying to club those both, which is perhaps not permissible because these are separate classes. These two set of employees are separate classes, and since they are separate classes, well, that classification, once I am excluded from that class, I cannot into that class and say there is I am further, Milad. Later on, options were invited in the prescribed pro forma by the interested deputationist of the state government employees, having required criteria for their permanent absorption in FCI reading circular number 21 of 1984. Once now here, interesting, I will read this portion, or I will be able to demonstrate, Milad, even how there are two different categories, Milad. Issued on 19th of March 1984, inter alia contained the following conditions. A, that the deputationist has to resign from the parent department prior to absorption and thus will be treated as direct recruits with effect from 1/7/1984 and will be subject to the terms and conditions as prescribed to the FCI staff regulation of 1971. FCI staff regulation of 1971 will also be applicable. Which the exam gets qualified and then medical and the entire process, advertisement by FCI, direct recruitment, and persons who are coming to and if permanently state government employees, Milad, once they exercise this prescribed option to the prescribed pro forma in terms of the circular of 1984, Milad, FCI are not the central government, Milad. The central government employees working under FCI had that option statutorily available to them, which the state government employees do not have. Rather, they have a statutory option under 71. That is fine criteria, Milad. I'm trying to, Milad, envisage, Milad. Now, Milad, I will come to the circular, Milad. May I read once more, Milad, because Milad, I just lost a little bit, Milad. The deputation has to resign from the parent post prior to absorption and thus will be treated as direct recruits. The date is given, effective date, and will be subject to the conditions of 71. Thus, they had agreed to be treated as direct recruits and be made a member of CPF under the FCI CPF regulation. So CPF regulation and liberalized pension scheme are two different, Milad, completely different, should I say, completely different stages, completely different setup. Somebody who comes within the contributory provident fund scheme cannot come under the liberalized pension scheme, which is prescribed under 12A. Now, Milad, circular, I will now place the circular, Milad.
At that time, the state government employees were not getting pension.
The Sangma pension, Milad. The FCI earlier when employed under the state government,
Yes, yes.
they were getting the state government pensions. Of course, why not?
So they were not having a contributory pension.
Once they come in, they are regulated under this regulation.
We have what you are trying to canvas, we just wanted to know that fact.
Yes, 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 yes.
If we have understood correctly, what you are trying to say is those who came from the government of India had no option but to come. They had an option to elect their service conditions. Those who came in from the state government, they had an option not to come. They could have stayed with their pension and whatever they were getting.
Precisely.
Come in accordance with the 1971 statute.
Once I exercise,
According to you, 12A is exclusive.
absolutely.
It excludes those other than government of India. This is what you have said.
Yes, well, I will come on the next day, Malad. I will only cite 3 judgments, Malad. I will conclude my arguments, the opening arguments today, Malad, by placing the documents today, Malad.
It's in the pension fund. That pension is available to the
And
employees.
the EPF, the Employees Provident Fund scheme, that is available
Deputationist
to the deputationist also.
Those details hardly matter.
It's just
What they will get is not an issue.
right.
Whether they can, according to you, at best they can claim a parity with the persons who are directly recruited. Because according to you, the direct recruits have nothing to save from their early service. Likewise, you treat them also that you have nothing to save from your earlier service because you have opted to come by these service conditions.
Yes, yes. Now, should we kindly take the 5th volume once, Malad?
Yes.
এবার ইংলিশ 607 থেকে দেখ পেজ 607 পরে পড়বো আগে আগে না বলো
607 I'm relying, Malad. Volume 5.
Yes.
But we have seen the top left hand corner, the date 26/11/66, Malad. Dear sir, I am directed by the governor of the state of West Bengal to the state that the government of West Bengal in the Department of Food and Supplies, hereinafter referred to as the government, has decided that your corporation should be entrusted with the undertaking involving reception, payment, purchase, storage, movement, transport, distribution, and sale of food grains and other food strews, I think, Malad. Within food stuff should be food stuff, Malad. It's a printing mistake, Malad. Typographical, Malad. Within West Bengal on behalf of the state government. Accordingly, I am directed to send you for your confirmation the terms and conditions stated below, which have been mutually agreed upon by the government and the Food Corporation of India, on which your corporation will take over the undertaking involving reception, payment, purchase, storage, movement, transport, distribution, and sale of food grains and other food stuff within the state of West Bengal on behalf of the state government. The terms and conditions above referred to. 1. This arrangement shall be deemed to come into force with effect from the 12th day of December 1966 and shall remain in force until determined as hereinafter provided. The corporation 2. The corporation shall, with the previous approval of the central government, establish a regional office at the Calcutta immediately before this arrangement. I am skipping this portion, Malad. 3rd, the corporation shall undertake all internal purchases, etc. Malad. I am skipping that as well, Malad. Now, Malad, 5A, I would, Malad, rely upon at page 609. No, Malad, I can skip this as well, Malad. I can 5A, B, C, I can skip, Malad. Yes, Lordship was mentioning, Malad, the takeover, Malad. In this agreement, 5C, specifies the corporation shall take over all the government store now and run by the government in the statutory rationed areas for retail distribution.
Initially, they had taken over everything, then
Yes,
state
yes,
food
yes.
corporations came into
Yes,
existence
yes,
in the
Milord.
various states.
I will come straight away to clause 9. Lordship was, Milord, right at the beginning, your Lordship was, Milord, mentioning 9A, B, and C, Milord. This, Milord, is relevant, Milord. To facilitate smooth transfer of functions under this agreement by the state government to the corporation, the latter shall take over all the officers and staffs of the state government actually engaged on these functions at present under the state government.
Yes. अभी रुकने बोला after 10 minutes, 15 minutes. Yes.
Unless for special reasons any of such officers and staff are not made available by the government for being so taken over. The corporation shall have the right to review its staffing pattern in the light of its experience and absorb such of the officers and staffs as were taken over by it initially and as may be found suitable for such absorption by a committee consisting of officers of the corporation and the state government. B. Such time as the employees of the state government taken over by the corporation are absorbed by the corporation, they will be on deputation. Such officers and staff on deputation shall continue to be governed by the same scale as of pay as under the state government. The other terms and conditions of their deputation will be settled by mutual consultation between the corporation and the state government, which in any case shall not be less favorable than what is admissible under the West Bengal rules. The corporation shall bear leave salary and pensionary contribution for the staff that would be on deputation to it. The other terms and conditions of their deputation will be settled by mutual consultation between the corporation and the state government, which in case shall not be less favorable to them what is admissible under the West Bengal government rules. The corporation shall bear leave salary and pensionary contribution to the staff that will be on deputation to C. In respect of officers and staff that will be eventually absorbed by the corporation in its service, the corporation shall make regular, that is, 71. Circular 21 of 1984, subsequently, Millard, will be eventually absorbed by the corporation in its service. The corporation shall make a regulation under the Food Corporation Act in such manner as to conform to as far as possible to the conditions of service that govern such officers and staff at present under the government. The corporation shall also relax, if necessary, its rules of recruitment in order to enable absorb officers and staff that will eventually absorbed the officers and staff that will be eventually absorbed in its service. Millard, I will Millard pause here, Millard, and then Lordship I'll take your Lordship to first the staff regulation. First the circular of 21 of 1984. That will Lordship will find at page 618.
Circular number
21, Millard, dated 19th March 1984.
So this is after the act. After the 1971 Act.
71 regulation, my lord.
Regulation.
Regulation, I will come back a little later, my lord. This act, my lord, also mentions the regulation. That's why the circular is relevant, my lord, why I am placing this one, my lord. Questions found that, my lord?
Yes.
The question regarding absorption of West Bengal state government deputationist in the FCI is engaging the attention of the management in order to ascertain the number in FCI. That's an extra one. So we'll kindly see right at the top. Absorption of West Bengal state government deputationist in regular service. So this circular was specifically made for the deputationist coming from the state of West Bengal, from the Food and Supplies Department.
And clause 3 of this circular is complied by the state government.
I'm sorry, my lord.
Clause 3 of this circular is being complied by the state government.
I'm sure it has been, my lord. That is so far my instructions are, my lord. I will take
Government of India circular issued for state government employees.
No.
Clause 3.
This is only for the deputations, my lord.
Yes, but it says the central state government shall continue.
My lord, the option was given under Annexure 1. Somebody opts for that option.
That we understood. We are just trying to understand whether 3 is being complied or not.
Yes, yes, absolutely. Yes, yes. Well, I thought, my lord, Roman 3 your lordship was.
No, 3.
I'm sorry, well, my bad, my bad. My lord, the absorption of the employees will be subject to the following conditions. 1, the state government employees who opt for permanent absorption in the service of the corporation will be treated as direct recruits, my lord. That was clarified, my lord, earlier also by myself, my lord, and will be subject to the terms and conditions as prescribed under the Staff Regulation 71. 2, they will count their seniority in the post grade in which they were absorbed from the date of absorption. It means somebody otherwise senior who is a direct recruit, but person coming in from the state government exercising Annexure 1 service, but is senior to treated senior to that person. So that's a seniority. The proposition, my lord, with regard to adhering to seniority squarely applies, my lord. Now, 3, my lord, details indicating the post as also corresponding post in FCI and the scale of pay attached to the post in FCI is indicated in Annexure. The employees who opt for absorption in will be initially appointed to the corresponding post indicated therein. So Annexure 1 is the option form. If I choose, very so interesting movie, Millard. I remember Mission Impossible, Millard. It's one line, Millard. If you choose to opt, Millard, its message is self-destructive in 5 seconds, Millard. It just came to my mind. So once I choose, Millard, everything else is self-destructive, Millard. I cannot go back, Millard. Cannot turn around and say, Millard, I will come under another category, Millard. So, Millard, now, Millard, 4, the West Bengal state government employees have been on deputation in FCI for a period of at least 5 years, and as on 30th of April 1984 will only be eligible for absorption in the service of the corporation. Now, 3 has been complied with. I'm skipping 3, Millard. 3 may I? Okay, I will read it for your lordship's convenience, Millard. For the service rendered prior to the date of absorption in FCI, the employees concerned will draw pro rata pension, death cum retirement, gratuity, and other terminal benefits, if any, as admissible from and in accordance with the rules and regulations of the West Bengal government. The FCI will not bear any liability in respect to the service rendered prior to the date of permanent absorption of the service of the corporation. My lord. 4, my lord, the persons who interested for permanent absorption in the service of the Food Corporation of India are required to give their option in the prescribed form in duplicate to the senior regional manager, West Bengal, Calcutta, duly countersigned. তো ল্যাপটপটা খোল, আমার তোর আইপ্যাডটা খোল, আমার এটা 1% ব্যাটারি আছে। In duplicate to the senior regional manager, West Bengal, Calcutta, duly countersigned by the controlling officer under whom they are working at the present before 30th April 1984. Now, Lordship will kindly take annexure 1 immediately below that.
Yes, we are looking at it.
Form. Annexure 1 is the option form. I blank of Sri blank holding the post of blank in the state government in the scale of pay of rupees blank.
So they have to agree to all that have been.
Yes, and they have. And they have.
So they have, according to you, this form they have accepted to be equated with direct recruits. So, but then in between 66 to 71 or 84, was there any distinction between the persons coming from Government of India and the state government?
There was always that distinction, Milord, because the amendment happened 67. So that distinction was always there.
We don't know as we want to know as a matter of fact.
I will, because, yes, I will come back with that, Milord.
Why we are asking you this question?
66 থেকে আগে থেকে
Because 12/11/1966 says that they shall continue as they are.
Yes, yes. I will take instructions
So
on that.
therefore, prior to filling up this form or annexure 1, was there any distinction in the two class, now which you are saying two class of persons, one coming from the state government and one coming from the Government of India, or till such time they were all at par?
I will find out, because well, the act is of 1964, Milord. What was the status?
But the option they are giving in 84.
No.
66 page 210, you want to specifically make that distinction with respect to state government.
This circular is of 84. 66 is an agreement.
Yes.
The agreement, as we have read, it says they will not be made a loser in any sense.
Yes.
They will continue as they are.
Yes.
So therefore, between 66 and 84, prior to their agreeing to becoming a direct recruit status, what was the position?
I will just. Roshni, kindly come back to 66 dog agreement once more, will it?
607.
607.
Yes. Come to 612.
Yes.
B.
Yes, correct. Yes, Milord. B and C. I am only under C, because C, B is Milord. This is scale of pay. I am not on scale of pay. I am only on the retirement benefits with regard to
No. B says salary and pensionary benefits.
Salary, yes, Milord, B.
Everything. So it is talking about the terms and conditions of service.
Yes.
To continue as it is. And then C says it is subject to formalization subsequently between the parties.
So till that formalization happened,
what was the status?
I will come back on that, Milord. On specific instructions, I'll come back to that. বলছে যে যখন at par রয়েছে, মানে what was the status till 84 came into play? I'll take your lordships. Well, yes, I have explained, my lord. I will come back on with regard to that part of the instructions, my lord, on the next day, my lord. But we'll kindly come back to 621, my lord, the 84 circular, my lord, circular 21 of 1984, my lord. Scale of rupees such and such in the corporation and be governed by FCI staff regulation 1971 specifically. Now here, my lord, once I am exercising this option in 1984, I will come to 71. That will be under the contributory provident fund scheme. I will come under 71. Prior to that, I will be governed under the state government's general provident fund schemes and rules. What I understand, my lord, perhaps, but I will take instructions, my lord, on this, my lord, since it has fallen from the bench, my lord.
B says without any change and B says,
Without any change, yes.
B says to be borne by you.
Yes. I will take both the instructions, my lord, and I will come back with that, my lord. I am agreeing to the following. 620, my lord, I have come back, my lord. I'm sorry, my lord. One, seniority in the grade post against which I am absorbed will be from the date of absorption in the corporation, and I shall not approach any court of law, tribunal, any authority on the issue of seniority. B, on my absorption, I agree to be treated as a direct recruit and made a member of the contributory provident fund under the FCI CPF regulation in 1967. As per regulation 17 of the FCI staff regulation 71, I agree to serve anywhere in India. I undertake the terms of conditions of the tripartite settlement between the management, etc. Well, I am not on that, my lord. Now, my lord, what will kindly come, my lord, to page 629. This is, my lord, the contributory provident fund regulation, that is at page 629. I will place this, my lord, and then I'll come back on the next day, my lord.
Option 4.
You will kindly see, my lord, the date is of 10th of May 1967, right at right top right corner, my lord.
We should continue on the next day.
Very good, my lord. I'll come. I'll start from here, my lord.
There are some parties in person who we want to
I'm sorry, my lord. Yes, my lord.
interact with in the chambers.
This matter, my lord. Yes. I'm sorry.
Yes.